Hello. Thanks for having me here. They've asked me today to come and talk to you about eyewitness identification. And what I'd like to do is, hey, stop! All right, y'all are now all eyewitnesses. You're eyewitnesses to my purse being stolen by my assistant. Can anybody describe him for me?
Tall, blonde hair, glasses, gray sweater.
Oh my God! You just blown my theory. What color pants was he wearing? Oh gosh, y'all are pretty good.
Columbia jacket, please.
He's a plant.
Well, he's looking at him. All right, come on in.
You can be more nondescript. Better at opening doors.
You're just not a very good thief. Thank you for that demonstration. I appreciate it, Chris. Chris is invaluable not only for stealing purses, but to me at my office. So thank you, Chris. Anyway, I do want to talk to y'all today about eyewitness identification and why it's really, really important, because as inherently unreliable as eyewitness identification is, it's very powerful when the jury hears it. And it's very hard to overcome when there's a witness on the witness stand identifying your client as the person that committed whatever horrible crime they're alleged to have committed. So what we need to do is we need to start trying to think about how we can move to suppress these identifications, especially, and what we do is we allege that they don't meet the requirements of due process. And before we get into sort of the nuts and bolts, and this is just a very simple sort of walkthrough, and it may be y'all have probably already done many, many Biggers hearings, so it may be too basic for you, but I do want to play this video, and it's a little outdated at this point, but let's see what we got. But I think it's still important. Jeez, y'all know who I am. Okay, here we go.
In the morning, I felt something in my room, something brushed my arm, and when I looked over the side of the bed, I noticed it was a person's head, and that's when I said, "Who is that? Who's there?" And he immediately sprang up on the bed and straddled my body, put a knife to my throat, and told me to shut up or he was going to kill me. Over the next 20 minutes during the assault, as he raped me, I made two decisions. One is if there was a way I could live, I would figure it out. And if I lived, I wanted to memorize everything about this person. So I began to pay really close attention to details about his face and his eyes and his voice and his hair and how much he weighed, the clothing he was wearing.
I was convinced that Jennifer would be able to recognize her assailant. She was able to provide a detailed description not only in terms of his physical appearance, but also what he wore at the time of the assault. It was clear to me that she had an ample opportunity to see him. Coupled with her determination and presence of mind, I was convinced without doubt that she could identify her assailant.
More than 250 convicted prisoners have been exonerated on the basis of DNA testing in the U.S. alone. Eyewitness misidentification played a role in more than 75% of those cases, making it the leading contributing factor to wrongful conviction. But unfortunately, witnesses are often wrong. How can this happen? And is it possible for us to prevent these eyewitness identification errors from happening?
We received an anonymous tip that Ronald Cotton not only fit the composite in terms of appearance, but the general description of the assailant. We had his photo on file, and we felt like he could be a good suspect in this particular case and thought that we should do a photographic lineup.
Within 2 days, I was asked to come down and look at a photo array. The officer said, "We're going to show you 6 photographs. Don't feel compelled to choose any one. The suspect may or may not be in there. When you're in the police department and there's a photo lineup, there's this sense that one of these has got to be their suspect, and it's my job to find him." I began to narrow it down. I could very quickly discount 4 of them, narrowing it down to 2 photographs.
According to the records, Jennifer examined the 2 photographs for 4 to 5 minutes. Research shows that memory is highly malleable and that an eyewitness who is uncertain can become much more certain over time.
I noticed that she did focus on photograph number 4 for a bit, then moved over to Ronald Cotton's photograph, which I think was number 6, before picking it up and saying that this was the man who raped me.
And I wanted to be very confident and very sure, so I took my time. And that's when I held up the picture of Ronald Cotton and said, this is the man who did this. They said, are you sure? And I said, I'm positive. And they looked at me and said, we thought that was the guy.
Since the officers present knew that Ronald Cotton was the suspect in this case, it's possible that they unconsciously provided information to Jennifer Thompson. And we do know that Jennifer Thompson's confidence was influenced by the positive feedback that she did receive after making her identification. In laboratory studies, researchers compare groups of participants who received feedback to individuals who did not receive that kind of information in a control group. And what we know is that people who receive feedback, their confidence skyrockets, just like it did for Jennifer Thompson after her identification in this case.
And there was this huge relief that washed over me because I had gotten it right.
On August 8th, 11 days after the assault, Jennifer Thompson was brought in to view a physical lineup consisting of 7 men. Ronald Cotton was the only lineup participant whose picture had been present in the photo array that Jennifer Thompson saw. And repeating only one individual in multiple procedures increases witness confidence even when that witness is wrong.
And as we walked out of the room, I remember looking at the officer saying, how did I do? Did I do okay? And one of the officers said, you did great. That was the guy you picked out in the photo lineup.
By the time she testified in court and identified Ronald Cotton as her assailant, she was 100% certain. Ronald Cotton's conviction was based primarily on the eyewitness identification evidence of Jennifer Thompson. But we know that Ronald Cotton was completely innocent of this crime. He was exonerated based on DNA evidence in June 1995. At the same time, it was learned that another man who was in prison for a very similar crime was actually the person who raped Jennifer Thompson.
I can remember thinking to myself, if that's wrong, if Bobby Poole raped me and it wasn't Ronald Cotton, then maybe everything I thought was true is not true.
Well, she just made an honest mistake. I was lucky that that was DNA evidence.
After having the opportunity to serve on the Actual Innocence Commission, I learned so much about memory, how it works. I learned about better practices that law enforcement could utilize as it relates to eyewitness identification. And it was incumbent upon me as police chief to move forward and embrace those recommendations. Because I certainly did not want to see this happen again to somebody else like Ronald Cotton. He lost 11 years of his life. I firmly believe because of a faulty eyewitness policy that we had in place in 1984. And something that actually continued to be common practice until 2008 in our state when eyewitness identification reform was made law.
Several easy-to-implement changes to procedures have been shown to significantly decrease the number of misidentifications in the states that have adopted them. The most crucial change to procedures is the double-blind administration of lineups. Double-blind administration is when the officer who's conducting the identification procedure is not aware of which lineup member is the suspect in the case. What's also critical is that the witness in the case is told that the officer doesn't know the identity of the suspect. In addition to double-blind administration, other best practices include proper lineup composition, instructions to the witness, confidence statements, recording the procedure, and sequential presentation.
Yeah, we're super close. We go across the country, do work on judicial reform or helping to pass bills or advocating for best practices or just talking to students at college and high school level. So we just stay really busy.
So that's pretty powerful. And While things have changed to some degree and better practices are being utilized by some of our law enforcement agencies, not all. I will say most of the photo lineups that are being generated are computer generated now, so they're a lot better than they used to be. But in terms of some of these better practices that they've talked about in the video, you know, there's no reform, there's no legislative reform, there's no judicial reform about this. So depending on your law enforcement agency, you may not be getting, you know, blind administration, where the officer that's showing the photo lineup doesn't know who the suspect is. So because the procedures are not being utilized the way they've discussed it in this video, that's really good place for you to start cross-examining your officers during these Biggers hearings. So let's kind of get into the nuts and the bolts of the Biggers. And after this video, I think what I'd like to do, instead of saying that we're going to talk about eyewitness identification, let's talk about eyewitness misidentification. Let's just assume that these identification procedures are inherently unreliable. And Neal versus Biggers, as you all probably know, that's your big case. That's your leading case. And that's a two-pronged test, as you probably know. First of all, you've got to have a police procedure that is unnecessarily suggestive. And that's important, and I've put the Wyatt case up there because that's one where the court, our Supreme Court, found that it was a suggestive lineup procedure. It was a show-up, and we're going to talk about show-ups in a minute, but that it was necessary under the circumstances of that Wyatt case. And we'll talk about that a little bit and get into that a little bit in a minute. But once you get over that first hurdle of an unnecessarily suggestive police procedure, then you get into your reliability factors. And here's where we'll talk about these factors, but we've got to show that there's a substantial likelihood of misidentification despite this suggestive procedure that the police have used to have somebody identify our clients. State versus Liverman's a good case just to kind of look at and talk about the reliability factors. Okay, so we know what show-up IDs are, right? Show-up IDs is where they grab our client, they take him back to the victim of the crime, and they say, hey, is this the guy that did it? Our case law says these are inherently, let's go to the next screen. These are inherently suggestive. So we've got that established. So if you've got a show-up ID, you've already jumped over that curve, unless, like they did in the Wyatt case, they find that it was necessary. And if what the Wyatt case tells us is the reasons for it being necessary, this show-up ID that's inherently suggestive, is it took place shortly after the crime, it was near the crime scene, and there was no time for the suspect to change or alter his or her looks, and the court says that it expedites the release of innocent people. So look at the Wyatt case. The Wyatt case had to do with, as I recall, somebody throwing contraband over a fence at a prison. The guy was running, and the prison guard was the eyewitness, and they found the guy walking down the road, and they brought him and showed him. And in that case, the court found that it was necessary. So we didn't get past that unnecessarily suggestive ID procedure. So what are some other suggestive police ID procedures? What can you think of that would make a lineup unnecessarily suggestive? Well, let's go ahead.
Not having anyone else in the lineup who looks anything like your client.
Exactly. And like I said, I think they've come a long way. I don't know what you and your practices are seeing. I think they've come a long way with our six-pack lineups, which is what we typically have, or at least my experience is what we have here in South Carolina. I've never seen a live lineup done, except maybe one case. So I think what we normally see here in South Carolina are these six-pack lineups. And of course you're going to be looking at these lineups to see, is my client standing out in any way because of physical characteristics, like you said. Height, weight, age, hairstyle, race, clothing. The lighting on these six-pack lineups. Shadows that might emphasize one person over another. These are all things that we need to look at when we're looking at these six-pack lineups. Yes, ma'am?
Can you just explain what a six-pack lineup is?
Yeah, I can. I certainly can. Well, that's not a six-pack lineup, but obviously, and some of this is kind of tongue-in-cheek and fun, but some of it's serious. the little guy with the piñata, of course. That's your six-pack lineup is going to kind of look like this, but hopefully better. Poor Bert.
So it's usually that photo.
I'm going to pull one up for you. There. This is, whoops, let me go back. This is what I get when I get my cases. This is typically, is this what you all get when you're getting your six-pack lineups? Something very, very similar to that. All right, let's just go through this. What's suggestive about this lineup?
Has to be an African-American male.
Yeah, and we've got that here. What's that?
The lighting.
Yeah, I mean, if this were my case and I was in trial, I would argue this was suggestive because of the lighting. I think he's sort of highlighted by that.
And he's closer, a little bit closer than some of the other people.
That's a really good point. So those are the types of things that we need to look at when we're looking at our six-pack lineups. Now I'm just going to go back. Let's see. So we've gotten over our first sort of hump and an unnecessarily suggestive identification procedure. So what's next? Supposedly, if you've gotten over that hump, you get a hearing. And judges call them different things. You'll hear them call identification hearings, ID hearings, Biggers hearings, Neal versus Biggers hearings. You have a right to that if you've made that showing. You've got a right to it pre-trial, outside the presence of the jury. Rule 104C, if the judge is looking for an evidentiary rule, you can always give that to the judge. I don't think judges give us a hard time a lot, or at least I don't see a hard time about having these Biggers hearings. Now, I will caution you, though, in April of this year, our Supreme Court decided State versus Warner, and that wasn't an eyewitness, and that's where they drew the line. In Warner, they kind of suspected Warner, but they weren't sure, and they had a video. I think it was maybe a convenience store robbery. They had a video of the crime scene. They took that video and showed it to somebody that wasn't an eyewitness to the robbery. They actually showed it to Warner's probation officer in Georgia, and he identified Warner from the crime scene photo. And the court in Warner said you weren't entitled to a Biggers hearing based on that. Be careful of that. Read that case and be ready for the state to argue that you're not entitled to it. So you've got your hearing, you've gotten over Warner, you've got this unnecessarily suggestive ID procedure. What do you need? Who are the witnesses you're going to need at the hearing? Let's get through these. I love these. Oh, I'm going the wrong way. Sorry, y'all. I just wanted to see these pictures again. All right, so we're going to need our investigating officer. We're going to need the officer who compiled the lineup. Usually, again, I think these are done by computer, and they're usually pretty good. When I first started practicing, they were terrible, but they're better now. You want, of course, the identifying witness. You want your exhibits there. You're going to have that six-pack lineup that we just talked about. Usually there's also a statement that's going to look something like that, and that's where you're going to look at things that the witness might have said. In this particular case, she said, the person looks most like the person that carjacked me and tried to kill me. So that's not a very confident statement, and that's a place where you can really cross-examine this witness about her confidence in her identification. So those are the things that you're going to want to have at your hearing. Okay, once we get over that first step, the first prong of the Neal versus Biggers step, then you get into your second prong, and those are your 5 factors of reliability. And they are the witness's opportunity to view the crime, or the perpetrator of the crime, the degree of attention, the accuracy of prior descriptions, the level of certainty, and that goes back to that statement she made in that report that he looked most like the person, and the length of time between the crime and the confrontation. This is great area for you to be cross-examining this witness on those sorts of things. Does anybody have any questions at this point? I think how many people have done a Biggers hearing? Okay. All right, well, let's talk about the reliability factors. We talked about State versus Wyatt already. Opportunity, lighting, what was the lighting like? What was the perpetrator wearing? Was he wearing a mask that's going to block his facial expressions or hers? Did the crime take place very quickly? Those are all areas where you want to be cross-examining this witness. The degree of attention. Were your eyes closed? Were you distracted? Were you worried about somebody, a child in the other room being hurt instead of you? Those are things we need to think about when we're questioning this witness. And again, this is all pre-trial. This isn't in front of a jury. So you can be a little bit harder with the witness at this point. Obviously, you want to be careful in front of a jury. You don't want to alienate the jury or think you're beating up on this witness. But pre-trial, just in front of the judge, I say have at it. You want to talk about the accuracy of the prior descriptions. Does it coincide with what she actually picked out of the lineup? Were there discrepancies? Were they just broad, general discrepancies that could have fit almost anyone in the room? Level of certainty, we heard about that, the confidence statements. We heard about that a little bit in the video. We talked about that in the statement. He looked most like the person that carjacked me. That's not very confident. And if there aren't any confidence statements, argue the state failed to prove that she was confident in her identification. Were there intervening lineups shown? That's always a good question to ask pre-trial. The other thing you want to do is cross-examine the officer, and here's where we can get into some of these procedures. Try to find out what your local law enforcement agency's procedures are when it comes to eyewitness identification. I can tell you some law enforcement agencies are doing a great job, others are not. So find out if there are procedures, see if your officers adhered to those procedures. Was there double-blind administration, proper lineup? We've talked about that. Instructions to the witness, and this is so interesting to me. I had a case on appeal where the police officer actually put down the photo lineup and say, okay, the robber, let's just say his name is Anthony. Do you see Anthony in this lineup? Guess what the defendant's name was? Anthony. I raised the issue on appeal. Unfortunately, my trial lawyer didn't. He argued that that was inherently suggestive. Unfortunately, he didn't argue any of the reliability factors, and the court said you didn't make your showing, so that didn't help. Did they record the ID procedure? That's really interesting. That's kind of rare. We don't get that a lot, but that's worth questioning. Was it a sequential? I don't see sequential. Sequential is when they would put an individual photograph and an individual photograph in. Well, that's not good. Instead of the six-pack lineups that we're used to. I'll try not to fling this around, y'all. Okay. Does anybody have any questions at this point? Yes, sir.
What's the intervening lineup? What is that?
If they've done more than one lineup. So they showed them a lineup, or say they do a show-up lineup, and then they do another lineup, and then they do another lineup. You don't get that a lot, but sometimes you do. So you want to ask about that. You want to find out about that if it's not in your discovery. Sometimes it's not. And it's worth asking the question. Consider hiring an expert. And I meant to get the list of experts from SCCID, but I'm sure there's a list of identification experts that you can get. And at this point, again, remember, we're pre-trial. So we're educating the judge. I think, since the time of the little video that we watched, we've come a long way, and I think people understand that eyewitness identification is pretty sketchy, but you still want to educate your judges, and having an expert available to do that's really helpful. That person can talk about memory fallibility, cross-racial identification, and again, just educate your judge. Okay, so you're going to do your motion to suppress at this point, and you're moving to suppress not only the identification procedure, but any in-court identification, because obviously your argument's going to be that that outside identification procedure tainted any in-court identification. So remember those two things. And what happens? Motion denied. Hopefully that doesn't happen to you. That happened to me a lot. And our courts they don't seem so interested in eyewitness identification. I haven't seen a good eyewitness identification case come up to the appellate courts in a while. But keep trying. I'm hoping there's going to be one soon. So your motion's denied. What do you do next? So the same sort of thing, well, first of all, you think, but your same sort of identification issues that you were arguing in front of the judge, now you're going to spin that just a little differently, because now you're going to have to be arguing these issues in front of the jury. And while you didn't convince the judge to suppress that ID, maybe we can convince the jury that this was a misidentification. So you sort of go through the same procedures. You challenge the witness with the reliability factors that we talked about. And again, you're not going to be as hard on the witness, depending on your witness, but you know, you're going to talk about opportunity, degree of attention, prior descriptions, level of certainty, all those things that the particular facts of your case are going to allow you to cross-examine that witness on. You're going to challenge the procedure like we talked about. Was it double-blind? Was the lineup composition done well? All of these things you can argue in front of the jury. It's not like a suppression hearing where once you lose, you can't argue it. This is different. You can argue these factors in front of the jury and convince that jury that this identification was simply unreliable. You've got your identification that you know is coming in at trial. Use your experts. Again, you might have lost in your suppression, but if you've got your expert already, bring that expert in and let that expert educate your jury about the dangers of misidentification. So, just in case you don't convince the jury that the identification wasn't reliable, and unfortunately your client gets convicted, which I know will not happen to anyone in this room ever. When it comes to my office, I want to just talk briefly about how you're going to preserve the identification issue for appellate review. You've got to object to all of the out-of-court identification testimony and evidence from all of the witnesses at the time they testify, contemporaneous objections. Now, the court's kind of playing with our preservation rules a little bit. I don't even want to talk about that. Object when the identification evidence comes in. Object, object, object. And don't forget, and I've seen this happen more than once, not only to the out of court, but when the witness is up there on the witness stand and says, that's the man who did it, please object then too. You have to object both times, both to the procedures and what they used from the six-pack lineup and when they identify your client in court. So, that's sort of the basics of a Neal versus Biggers identification hearing. Yes, ma'am.
Maybe this is a silly question, but what's the exact objection?
The objection, well, you're going to be arguing, like we talked about, based on all those factors, that the identification is unreliable based on your pretrial rulings.
Got it. Okay.
And it'll be a violation of due process.
Okay.
Due process requires that identifications be reliable. And that Neal versus Biggers case gives you lots of good language. State versus Liverman gives you lots of good language. The Wyatt case gives you some good language. So those are good cases just to have in your trial notebook, and if the judge pushes you on it, you've got those, and you can. That's a good question. So anyway, well, good luck. Keep pushing it. Like I said, the court doesn't seem very interested. I will briefly talk about one of my cases, and I'm still a little salty about it because I lost. But this was a case where a bank teller misidentified someone. She identified somebody that wasn't the person they put on trial. They never put my client in a photo lineup for the bank teller to identify. But they allowed her to come into court and say, that's the man that did it. Now, she's an eyewitness, and the court said, well, no harm, no foul. You got to cross-examine her about this other person that she identified. But I think if that's not a showing of inherent unreliability, I don't know what is. And there is some federal case law out there and case law from other jurisdictions that says that can't happen. Our court is not interested in it. They didn't want to talk about it at all. I sorted it up. They didn't want to talk about it in the Supreme Court. So I'm not telling you there's any good case law to help you in our state, but if you want some good out-of-state case law to try that, give me a call. I'm always happy to talk to you. I'm happy to talk to you anytime about anything, but I'm happy to give you that case law as well. Any other questions? Yeah. Hi, Derek.
Hey, Kat, would you agree it's basically malpractice to not have, to not call you before we have a Biggers hearing?
I don't know if it's malpractice thing, but I'm happy to talk. I'm happy to talk with you about it. It's always nice to talk with somebody. If it's not me, if you don't want to call me, talk with people in your office about it. Make sure you're jumping through these hoops. Again, I'm happy to talk. Anybody in my office is happy to talk. I'm not going to go as far as to say it's malpractice, but we would like it, and we would like it to be preserved for appellate review so we could continue to challenge if by some slim chance you don't win at the trial level. All right. Well, I hope y'all have a great Thanksgiving holiday, and thank you for letting me come talk. Again, my name's Kat Hudgins, and please, I'm at Appellate Defense. Call me anytime. I'm happy to talk and discuss anything you'd like to talk about, but especially Neal versus Biggers.